It's 2020 and currently the world is experiencing a crisis like never seen before. The coronavirus has rapidly spread across the globe, collapsing industries, hospitalising thousands of people and resulting in many fatalities. In this episode, we're speaking with Sarah Wallace, a lead regulatory and corporate crime lawyer and partner with Constantine Law. In a follow-up to the previous podcast about investigations, we're having a conversation about consequence management arising after investigations have completed.
Okay, good evening everyone. Welcome to the next episode of the Skadi podcast. We are taking it further from the last episode, which was talking about internal investigations. And I'm joined this evening by Sarah Wallace, who is a partner with Constantine Law. Sarah has a very long and varied career, starting actually in audit with KPMG, but moving through the Financial Conduct Authority and the regulator, through to a career in law, focusing predominantly on internal investigations and also on employment and HR-related matters. So I think none better really to join us and talk about our next topic, which is the topic of consequence management and things related to that in internal investigations. So welcome, Sarah. Thanks very, very much for joining us. So can you tell us a little bit about how you've been taken into the world of internal investigations?
Yeah, so, I mean, you're right to say investigations is sort of my bread and butter work. I mean, I started off life about 25 years ago after KPMG, training to be a criminal solicitor. And so, I would spend the first couple of years of my career, it was going to police stations in the evening and then clearing the cells of the magistrate's court in the morning. And then I moved on to financial crime, financial investigations, because I'm quite mathematical and I love that subject matter. And for a couple of years, defending back-to-back SFO, serious fraud office investigations. You're quite right. I did a stint on secondment at what was then the Financial Services Authority, still in contact with a lot of people who still work there and who've left. And that sort of brought me into the world of, the FCA investigates criminal offences like insider dealing. That brought me into the world of regulatory investigations. And then I would say, probably about 10 years ago, for me, or 8 years ago, you started to have the rise of the internal investigation. And I would say at the moment, internal investigations are at their peak. And I don't think that will dip off. I think after we get through, this ghastly pandemic, sadly, I think there will be a spate of internal investigations relating to behaviours that have been uncovered through the period we're going through now.
So obviously you have it's recent, but a long experience in internal investigations, and that's kind of, it's slightly longer than Skadi's, where we've been at it, I guess, sort of 8 years, but slightly longer yourself. Perhaps for the listeners, you could just take us through really what the typical involvement would be in your mind for a law firm working with, let's say, a medium-sized financial institution that could be presented for the first time, let's say, with an internal investigation. And I guess, as you say, statistically, that the probability of this is quite high, given the situation that we've been in, the potential for things to have gone wrong during the lockdown and so on and so forth this year. What are the sort of steps that they would take?
Yeah, you asked, at what point lawyers get involved. I think the first thing is, if you're a firm that is regulated by a regulatory body, that there is a greater scrutiny in relation to the firm and individuals' behaviours. And so you and I come from the world of financial services, and financial services is intensely regulated by the FCA, the PRA, and sometimes global regulators around the world. So that's sort of generally one of the reasons why there'll be an internal investigation. Another big reason, not the only reason why you do an internal investigation, but it can be because you've got to notify your regulator, and it could lead to regulatory or disciplinary action. And so there's a real emphasis or requirement that you have to get to the bottom of what may or may not have gone wrong. So lawyers sometimes are involved when there's a risk of, the external regulators are very keen to know what you're doing and whether there's been a problem. Another reason can be because the board of directors might be involved, and so it's difficult for them to oversee or to have independence of an internal investigation. So law firms or investigators like yourselves are brought in to give a degree of independence to the process. One of the things that, I mean, it's always a judgment call as to whether you involve solicitors, because obviously there's a cost that comes to that. But another reason sometimes is because you want to maintain privilege or a higher level of confidentiality over what you're looking into, because further down the line, there might be risk of litigation around it. And so the firm is keen for the cloak, umbrella of privilege, which means that it's harder for privileged material to be disclosed to the outside world.
Right. Okay. And I think privilege probably is quite a consideration for people. I mean, you've given quite a good overall sort of explanation of what privilege is, but a lot of our listeners will come from the audit world, the compliance world. Is there a very kind of good layman's overview you could give to them, just in a nutshell, of what privilege
means? Nick, there are textbooks written on privilege, and there's also quite a lot of litigation going on now as to what's privileged and what isn't, actually, interestingly, often in the context of internal investigations. Generally, the work that a firm is doing with a solicitor has to relate to the giving of legal advice, or if there's a reasonable likelihood of litigation, the communications between the client in relation to legal advice in relation to that, and then its litigation privilege is slightly wider. It covers communications with third parties as well. But it's got to revolve around the giving of legal advice. And in the context of internal investigations, there's been a lot of court cases about whether interview notes of a interview with a witness with a lawyer being present is privileged or not. So not every communication that a firm has with solicitors is privileged, but if it is connected with the giving of legal advice, then you can run an argument that it is. If you label something privileged, that's a starting point to getting to an evidential basis that it is. But just because something's called privileged doesn't necessarily mean that it is.
And it is an interesting point, because as you say, it's about the giving of legal advice, and that it obviously is dependent on the people that you're working for. Who are you actually working for in an investigation if you're brought in? Are you working for the directors of the firm? Would you be working for the shareholders? Would you be working for the employees? How would it work?
Yes, okay, that's a good question. So you have to define who your client is. So if a company instructs, then the firm is the client, and that's the entity, the legal person that's receiving the advice. As a bit of an FYI, of course, if you're giving advice to a company and those who run the company change at a later date, those new people running the company further down the line might decide to waive privilege and reveal the privilege to the outside world. But no, if you're acting for a company, the company is the client. But I mean, what my practice is to do is to say who is going to give instructions on behalf of the company, and that might be the board, or it might be a couple of board members. Sometimes in the context of internal investigation, if the board is conflicted, you sometimes have a separate committee that is formed, maybe of a couple of non-executive directors, possibly another senior manager, and they provide the instructions in relation to the internal investigation, and they receive the legal advice in relation to it. But I think the thing that's important to note is if you make your client group too wide, then there's a risk that privilege could be lost. And directors have to understand that they are not the recipient of that advice, and so a new board could decide to waive that privilege, which sometimes can cause difficulties if the previous board hasn't necessarily followed legal advice. And so there can be this unpicking of privilege in the context of an internal investigation. If your client is an individual, so a board member, then they would be the client, and they would own the privilege. It's for them to say whether or not privilege is waived. So one of the things in internal investigations is, who's your client? Is it an individual who you're acting for, or is it the company?
Yeah. Okay.
And those interests might be aligned, or they might be aligned but diverge, or they may be diverged right from the beginning.
Yeah. Now that's an interesting point. And where does that leave the firm with regard to their obligations to the regulator versus their use of privilege to protect themselves?
Yeah, another good question. So no regulator or prosecution authority will can compel you to hand over privileged material. That privilege is entrenched in English law, and other jurisdictions around the world recognise privilege in the same way. However, there is a huge emphasis on what is called cooperation, and the FCA may expect the product of an investigation, whether it's privileged or not, to be shared with them, and there may be a tension if it isn't. In the Serious Fraud Office world of deferred prosecution agreements, there's a lot written about the extent to which privileged material should be shared. And I'm a lawyer, so I'm very highly respectful of privilege, and one gives advice and takes instructions. So I'm not going to say, if you're in an internal investigation, you will definitely have to hand over the product. Some large institutions don't cloak their investigations with privilege. It all depends. A more cautious approach would be to cloak it with privilege if you're using lawyers to begin with, because you can always waive that privilege at a later date. If you don't cloak it in privilege, if you can, then it may be harder to reverse that at a later date.
Right. Okay, I understand. So it's kind of a prudent measure to take at the outset, and then you can determine later.
Yeah.
What happens and how you.
Yeah. I mean, a lot will depend on what the factual subject matter of the investigation is. So if it's something that's going to be reputationally damaging, if it's something that could lead to shareholder disputes and claims against you, those are drivers, I probably would say, to ensure that privilege is there. The trouble with internal investigations is that you don't always, if you had a crystal ball, it would be easy so often what I'm doing is it's prescience. It's putting your mind forward a year, 2 years, 5 years down the line, and sort of trying to do damage limitation. But at the moment there's a lot of emphasis on non-financial misconduct. So factually that can be like a bullying case, a harassment case, maybe a degree of sexual impropriety, and those are reputationally quite damaging. They can be quite damaging for the individuals involved, but there's a lot of emphasis on those types of cases, and often firms are looking at them quite seriously, but they would have taken a very different view maybe five years ago as to how those types of things are investigated.
I think that's a really fascinating point, because I think you're so right about the rate at which the world is changing, particularly with regard to attitudes, with regard to culture, but also with regard to the increased transparency and the line of sight that the general public have over activities that, just because of the nature of communications and how fast those are changing, people wouldn't have had that line of sight 10 years ago, 15 years ago. I mean, certainly, I think of the communications at the start of my career, when I was back working at Barings, and, the collapse of that noble firm. Can I imagine what the reaction in the media would be if that happened today, and the speed at which things would be known and discussed and poured over, very, very different. So that must make a lawyer's job quite difficult, or solicitor's job quite difficult. Working, as you say, with your crystal ball, trying to look, 3-5 years ahead, with attitudes changing so quickly.
Well, I think it's just the cautious nature. I mean, I can't say all lawyers are cautious, but lawyers do tend to be quite cautious, attention to detail, and you're making educated guesses or best guesses, and it's not perfect. So you're sort of trying to do a bit of a damage limitation, but you have to also measure the temperature of your clients. And some clients would say, no, we're an open book and we'll share everything with the regulator, warts. It just depends.
So looking at the internal investigations and thinking about the consequence management, really, and this obviously is probably a difficult question to answer because I'm sure it's not an easy thing, but in general terms, when do you find that you move from a kind of investigating phase, fact-finding phase in an investigation, to when do you really start to sort of move to the right, okay, how do we deal with this now? What actions are we going to take? Moving towards the kind of consequence management. Is that quite a delineated process? Is that something that is different for each investigation? How does it kind of work out?
I think you generally have an idea as to what the issues may be, even from fairly early on. Doesn't mean that all of those issues will manifest itself, and doesn't mean that all of the issues, that there won't be new ones that arise. I mean, it can unfortunately happen that you start investigating A, and through looking at A, you discover B and C.
Yeah,
which are worse. I mean, and again, that you certainly saw that at the end of the last financial crisis. There were big investigations, often around banks and trading, and a lot of things. They investigators saw, and it led them off down another path. But there are certain things are fairly. It doesn't mean this will happen in every case, but obviously, risk of regulatory investigation. What the regulator will say. If individuals have done something wrong, will that lead to a disciplinary? In which case, you're using your HR teams, your employment lawyers, whether in-house or external. There may be a parting of the ways. There are accountability issues. You may have people who haven't been part of the problem; they're just accountable, and they might go. So you have that. I mean, something that's come up through the senior SMCR. There's quite a lot of now attention on whether a conduct rule has been breached, and you can agonise, as to whether or not that has happened, and then what that effect would have on the individual concerned. There's a lot now, again, out of the last financial crisis, the linking of conduct with pay, and of course that will then trigger issues if someone's pay is reduced or has an impact on share schemes, that type of thing. If it's fraud or financial crime that you're investigating, do you have to go after money? Do you have to try and track lost money down? Civil proceedings against the perpetrators. Again, it depends on the firm, but it could be very damaging reputationally. Do you need PR advisors to be talking externally about what's happened? Do you? There seems to be a trend now. I mean, this is not my area of expertise, but there is a trend if it's a listed company to make an announcement to the market about the investigation that can have an effect on share price. So there's a huge number of things involved, and it will just depend on the facts, what you're doing when, and also I suppose the size of the company, whether you're a household name or do you have investors who may be unsettled. Will you have customers? Will your trust and confidence be lost with there's all. So I think there are fairly tried and tested issues that you need to think about, but it's just applying it to the facts of the investigation and your client.
Yes, I mean, finance is obviously an interesting industry, just given its global reach. And there's been, I mean, certainly in my career time, a lot of attention given to the kind of nature of behaviour where people, essentially just moved on shop to shop ahead of problems. And I'm wondering now, what are your obligations as a firm if you have something? Because with Skadi, we investigate historic things all the time, and the nature of how rapidly staff turnaround is in the financial industry, it's really quite high, especially if we're going back looking at a problem 6-7 years ago, which is not uncommon for us. And certainly a lot of the people involved in that investigation may no longer be with the firm, but some may even have gone overseas. What are your obligations to as a firm to people that have moved outside of the firm, and then indeed people that have moved overseas?
Yeah, I mean, it's in the FCA rulebook. I mean, there may be notification obligations to the FCA in relation to senior personnel. There's a whole raft of notification obligations in relation to conduct rule breaches. So there will be a degree of notification to the FCA in certain cases. If you're a senior manager, you still complete a Form A, and there's a huge amount of disclosure that has to be made on that form. It's a very difficult form to complete. It's some quite complicated questions, and often people innocently answer things not quite right, and sometimes the FCA can pick you up on that. But I mean, the main thing is the regulatory reference, which sort of follows you through your career here. I can't speak so much as to what happens outside of the UK, I'm afraid. I mean, a lot of European, I mean, having said that, a lot of financial services law derives back from European legislation. So to the extent we're still in Europe, there might be some changes with Brexit, but there's a similar way in which information is sought when you move between firms in Europe. But it's the regulatory reference, which the idea of it is it's the firm that you're leaving has to disclose things that are potentially relevant to conduct and fitness and propriety.
Right.
That's the idea. It's quite a complicated reference to complete, and sometimes firms struggle with what's disclosed. I mean, sometimes there's a knee-jerk reaction to disclose everything. I mean, I tend to say the advice that I give is you should only disclose if you need to disclose, because if something goes on the form that shouldn't be there, you potentially open yourself up to criticism from the departing employee, and it can cause ramifications in relation, to, can be career limiting. Or the risk is if something's on the form that shouldn't be on there, it could affect a future employment.
Right. And can employees see that form that's been produced by the firm?
It's typically the firm will produce it and then provide it. Right. It's not let's fill this form. Well, the ones that when I've advised on the completion of those forms, it's not one that we've done. It depends. I mean, if an employee, generally a firm will do it. If an employee knows that they are leaving, then they can make inquiries as to how the form will be completed. Mm-hmm. But generally firms would, I mean, the position, it's an obligation on the firm to complete the form accurately. And it's just quite tricky because there's time periods. It's 6 years from the date of the request for a regulatory reference. Whether something's serious misconduct or not, there are various definitions that you have to interpret, and then whether something affects fitness and propriety. So sometimes it's very straightforward. Sometimes it isn't.
Okay, thank you, Sarah. And looking at certainly the work that we carry out, I'd say a significant number of the investigations that we get involved with are whistleblower related or whistleblower led. Any special considerations for investigations involving whistleblowers from a consequence management point of view? I mean, what are the obligations of the whistleblower, for example? Well,
okay, so the whistleblower may just be reporting something that they've seen. It could be that they're making a grievance as well. So it's just some sort of very general principles. I mean, the FCA are very bothered about whistleblower, about speak up, that it works, that systems are in, proper program systems are in place, clearly communicated, people feel comfortable and able to report things. Or they will be, and they will be investigated where necessary. And so one of the things which, from a firm perspective, is you can't, you've got to give updates to a whistleblower so they know what's going on. But they're obviously not going to get the detail of what's going on. Sometimes whistleblowers are quite impatient. They think things should happen quite quickly, and sometimes investigations are quite slow for good reason. Sometimes there's a slight growing interest in whistleblowers who can whistleblow in America, because in America people get rewarded. Whistleblowers can be rewarded if fines are imposed. We don't have that here at the moment. So it depends on. Trying to answer your question, it sort of depends on the whistleblower. Sometimes it can be a family member who is the whistleblower, who is reporting something through a whistleblowing line.
Right. Okay. So,
I mean, some whistleblowers might be fearful for their positions. So anonymity can be very important within an organisation, that their identity isn't revealed.
I'm sort of interested in to what extent, and obviously you've talked about privilege and the fact that the law firm may be working for, instructed by the firm, etc. I'm just interested in how much one has to tell the whistleblower after an investigation is done, and particularly as you observe in the UK, there's no reward for whistleblowing. The US there could be potentially significant reward for whistleblowing. So I'm just trying to understand what the firm needs to provide or should provide to a whistleblower that's raised some allegations when they've been finally investigated. Is it purely, look, we've investigated, we didn't find anything, or do they have to really provide some kind of evidential base to what they've seen?
Yeah, I don't think you'd be providing the investigation report, but you would, you would probably want to explain in general, if you can. I mean, it might be that the outcomes are really quite confidential. It would depend on the situation as to what you can properly tell the whistleblower.
I see.
It would depend, because if I think you obviously want them to know. I mean, it can be that nothing comes of it. It will just depend, and you would probably, if you can, try and give them an explanation in general terms. But it might be that the outcomes are confidential. It would just depend.
And I guess one sort of last sort of topic I would like to explore, because Skadi generally works for firms. We tend to be investigating individuals. I'd just kind of like to flip that around on its head so I can understand what it would be like from the other way. So how would you work with individuals that are being investigated? How does a law?
Yes. Yeah, so I act for both firms and individuals, so I see it from both sides. So in terms of an individual, it depends. Okay, in general, it would depend who you are. Are you the suspect? Are you a witness? Are you the victim? Are you a whistleblower? And your level of stress will vary depending on where you are in those categories. If you're at risk of having done something wrong, it's pretty brutal. It's very stressful. You're having to deal with it on top of the day job. You may be given some time to prepare and to deal with it, and depending on the seriousness of the allegations and whether they can be career limiting or at worst career ending, it isn't always a happy place to be. Having said that, a lot of senior people do get caught up in investigations, either as generally in the investigation you don't always say the suspect, but as someone where there might be a finding against them. And to a certain extent, it's an occupational hazard of the senior position that you're in intensely regulated, sector. And so, you have to be able to deal with it because that's part of the job. So just say, generally, if you're at risk of being accused of having committed criminal offence, that's can be worrying, and things like that go on a long time. That's, I think, what people probably find quite hard to and the public often will be surprised about this. 10 years after the last financial crisis, regulators were still looking into the tail ends of things that happened in 2008. I mean, and for individuals, that's very draining, particularly if you've lost your job as well.
Yeah.
It can be really hard. If you're a witness, generally, you've just got to dig in and deal with it, and no one relishes, being interviewed if they don't need to be. The thing about an internal investigation interview is it's not really a fireside chat. It's not really what's going on, particularly if external lawyers or investigators are brought in. There is a formality to it. Often you're having to cast your mind back, some time, or even if you're casting your mind back a couple of months. We work at such a rapid pace now. You've got to refresh your memory. And so if I'm working with individuals, we spend a long time, trying to refresh memory, look at documents to bring it all back so that there's a degree of accuracy in what's being said. But anyway, if you're a witness, it's not as bad, but it's something that you've got to deal with in a professional way. If you're a whistleblower, it depends what you're whistleblowing about. I mean, generally whistleblowers find it very stressful as well. They're carrying a lot, which they, worried about, the ramifications for them personally, and probably the same with victims. So it's generally stressful and confusing, and having someone on your side explaining, representing you is generally quite helpful.
Thank you, Sarah. Just one thing you just raised there about how far back, and how long it takes to work through a cycle. And as you say, 10 years after the financial crisis, people still looking at those cases. And I can certainly back up that observation. Is there a rule of thumb, particularly, when you have a whistleblow allegation comes to you? Is there a rule of thumb for firms about how far they have to really go back and look at something in terms of time? Or does actually, it's been so long now, it's not worth going back, or not say not worth going back, we just won't be obliged to go back and look at this?
Yeah, I wouldn't say there's a rule of thumb. It would depend on the facts. But if you have an allegation about an individual who's still there, and it was the serious allegation, you probably would have to go back.
So it's really about the seriousness of the allegation, and also who is still around, accountable at the time.
Yeah, I know, whether it would just... Okay, so, I mean, going back to the non-financial misconduct, if it was a really serious allegation, I'm not sure you could sweep that under the carpet. If there was harm to consumers, you probably need to look at that. I mean, one of the things I didn't mention, but when you have one of the consequences of an investigation is, is there customer detriment? Is there redress that's needed? Yeah, I mean, I think you can be criticised now, for not looking into something. So I think there isn't a sort of one size fits all answer to that. You would need to look at it carefully, and then if you decided not to pursue it, you'd want to document those reasons carefully.
Right. I get it. Thank you. Well, Sarah, that's been an absolutely fascinating look into this subject, which I could tell, I think we could have 4 or 5 podcasts about this. It's very, very, very complicated. And I really want to thank you for cramming so much into to that last episode of the Skadi podcast. Thank you very, very much for joining us.
Thank you for listening to episode 9 of the Skadi podcast. Stick with us on this journey, as we, like many of you, are trying to navigate these very uncertain times. This is the Skadi podcast.